Welcome to today's webinar, which is a collaborative effort between plaintiff and defense firms. We're coming together to help both employers and employees understand the new litigation arising from the coronavirus pandemic. Today's panelists are Todd Stanton, Managing Partner of Stanton Law, an employment defense practice, and Amanda Farahany, Managing Partner of Barrett Farahany, a plaintiff's employment law practice. I am Kathy Sullivan, I'm your moderator, and I'm also a partner at Barrett Farahany, and we are all here to help clarify as much as possible these new rights and obligations coming into play for everyone. And by doing that, we hope we can help promote cooperation between employers and employees and minimize potential litigation so that everybody comes out of this in as good a shape as possible. So I'm just going to go ahead and kick off the questions by first of all asking Todd and Amanda, and you guys can take whichever turns you'd like, about just an overview and your perspective of the current situation and your feelings about where this is going, or any particular thoughts you have as this thing unfolds.
Amanda, you want to go first?
Sure. I think, the overarching thing that I would tell people is that we're all in this together. And so while it might seem as though it's a very scary thing, and of course it is a very scary thing, I think you're going to learn today that there's going to be available remedies for a lot of different companies and a lot of different employees, and that not to panic. So we're going to talk through the different laws that are available. The stimulus bill that's coming through probably today is going to provide a lot of resources for both companies and being able to move forward and keep companies in business, as well as for people, even if they're not employed by the company. What about you, Todd?
Yeah, I would echo that. I think that the first week was certainly chaos, going back to the 12th. The passage of the act, the Family's First Coronavirus Response Act, was a big bomb that went off that had everybody panicked. We've kind of settled down, and we're getting used to what the rhythm is going to be on this, and we're learning more and more about this every day. I think that, as we were discussing earlier, there are always going to be a very small minority of employees and a very small minority of employers who cause a lot of problems. That's how Amanda and I make our living, quite honestly. And if we can back off and understand that most employers are trying to do the right thing, and if you're on this call, we've got 175 folks on the call right now, that means you're willing to listen to what's going on, and you're making the best effort to do the right thing, either as an employer or as an employee. We'll have to clean up a bunch of messes later, but let's do the best we can with the information we have right now. And I think that coming out of this webinar, with anything else, more information is better. And that frequent, clear communication between employers and their attorney, employees and their attorney if they have one, and certainly between employers and their employees, more is better is going to be our pretty consistent advice when it comes to how to get through this.
So a lot of the questions that we're getting and the ones we're currently getting on the chat have to do with what are people's legal rights and what is this new legislation going to do for employees who are worried about catching the virus, worried about having to take care of a loved one who may be showing symptoms or whatnot. Let's talk about the new sick leave legislation that came out and what that means for both employers and employees. I think one of the places that we all discussed earlier where there may be some gray area is who can take this sick leave and whether or not the sick leave is going to be available to people who are laid off or furloughed. Can you guys talk about that?
Yeah, this was I think as we were preparing for this call, probably the biggest area of disagreement where defense and plaintiffs are going to see a little bit differently on this. My opinion is the defense has the correct position, but we'll see. The issue is that, as we see it, is whether a furloughed employee, somebody who doesn't have any work, by furlough I'm meaning somebody with reduced hours all the way down to 0. So they're still technically an employee, but they are not working. There's no work to do. An employer has asked them to stay at home. Certainly, if we terminate, if they're not an employee anymore, we don't believe that they have paid sick leave rights or family rights. And I don't think that that's the area of disagreement. Where we do disagree is what happens when there is say a full-time employee who normally works 8+ hours a day, qualifies for 80 hours of sick leave, but their employer doesn't have the work and they move down to a 2-hour, 4-hour schedule per day or 15 hours per week, whatever it's going to be. It is Stanton Law's position that if there is no work to do, that they can't take sick leave for the hours that they wouldn't be working. So if an employee gets down to where they have 15 hours of work scheduled, they can take 15 hours of sick leave and be paid for that, assuming that they qualify under one of the other 6 reasons. I'll let Amanda describe how she reads it, which is, I think neither of us have great support for we don't have legal support for it. We've got logical support for it. But I think her position is that they are eligible for up to 8 hours of sick leave a day if they're a full-time employee, the 80 hours over the 2 weeks. But I don't believe that they will be paid for sick leave if there is not work to do.
I think it's really going to. I think it's really going to depend overall on what's happening at the employment situation and what the employer is trying to accomplish. We've got a multitude of different things that are in play right now. You've got the sick leave benefits that allow for somebody who is unable to work because of taking care of somebody who's sick or because their kid is out of school and so they don't have childcare. So that's really where the sick leave is going to come into play. On the other hand, if the company doesn't have work, we've got unemployment benefits that are kicking in. And so an employer can put in those unemployment benefits, not even terminate the person, even if there's reduced hours worked. And that's different than what we usually see in unemployment. So usually unemployment is either you're terminated or you're not terminated. But instead now, with unemployment, what we have is if there's a reduction, you can get unemployment benefits. Either way.
You and I agree on that point, Amanda, excuse me, that there are benefits available for people who aren't working. Our position is it's not through that paid sick leave if there's no work to do, but certainly they're entitled to that. They're eligible for that unemployment.
Right. So it may be just a question of who's making those payments as to which way is the right way to go. What I think that the 3 intersections that all employers are going to have to be looking at, both for that short-term 2-week period and the larger period of time, is the intersection between this new law, the stimulus law that's probably going to pass today under the Paycheck Protection Act, where the employers are being given money to cover payroll, unemployment, which is the government giving money to cover it, or whether the employer is going to be covering that sick leave and then getting that money back through tax credits. So that's really the interplay that I think probably people need to understand today as they're making those decisions. But it's, in my opinion, going to be really a question of what happens after that 2-week period. Do you want to keep that person? Is there going to be work? Is this a temporary situation, or is this something that's a longer-term situation? But not everyone's going to be entitled to the sick leave anyway, because it's only to take care of yourself, or if you've been quarantined, or because of being sick, or because of not having childcare.
Let me bounce off of that. Let me bounce off of that point really quickly, because I think that is very important for everybody to understand. I think this is going to be a very limited use statute. I don't think as many people as the lawmakers hoped would qualify for it will. We don't know, but especially and then FAMLA would be even more restrictive with just the one reason about childcare, not being able to work and not being able to work remotely. I think there's going to be a lot fewer people eligible to take this benefit than most people think. And that's why I think that getting this out here so that employees understand what's coming down the pike, that it is not a pot of gold at the end of the rainbow. And for employers, it's not a death knell. It's going to be a big of expense as some people are afraid of right now.
Well, and I think we also, when we discussed this earlier, talked about the fact that, in some cases, as strange as this may sound, then, a complete termination may be better for the employee with the expanded unemployment benefits now versus a 2-week paid leave with the employer. Did you guys want to touch on that?
Yeah, let's start with the sick leave. So under the sick leave, people are not required to be paid their full pay if they're making above a certain amount, right? It's a 2/3 of their pay up to a total of $2,500 a week.
No,
for certain kinds.
You're right to the extent that it's $500 per day if it's a self-care, up to $500 per day if it's self-care, up to 2/3 of their pay capped at $200 if it is for care of somebody else. But to Kathy's point, I agree with you that the expanded unemployment benefits, not to be insensitive about, are going to be richer than the paid sick leave in many cases. And so I don't think that it's worth firing people just to avoid the paid sick leave, but it may ultimately be in their best interest. And this is another point of agreement that Amanda and I had earlier. If employers are trying to avoid the sick leave benefit, I would counsel against that. It's not that bad. And certainly, if you start targeting folks who you think are more likely to use the sick leave benefit, whether they're older population, whether they are single moms, for instance, who might have childcare issues, you're going to be setting yourself up for a potential interference claim when it really wouldn't have been that burdensome to provide the benefit in the first place.
Right. And on the other hand, if you terminate people and you terminate just the ones that you consider to be at higher risk because they're older or have underlying health conditions, then you're probably going to be violating the Americans with Disabilities Act or the Age Discrimination and Employment Act. So, making decisions to terminate is going to be something that you need to do on a broader scale. But for employees, the employee's rights under the unemployment right now is going to be pretty broad. And that doesn't mean just because someone's unemployed, they can be furloughed and you can still intend to bring them back under this. But there's rights for employees. There's also rights for hourly workers that are part-time. There's rights under unemployment for people who are self-employed and gig workers, which there's never been anything like that before. So that's a huge benefit for people who are working for themselves or working in the gig economy. And in the past, what we've had is a waiting period of up to a week before people can get their unemployment. This is happening automatically without a wait period. Georgia is one of the most restrictive of unemployment. And so we limit the unemployment benefits to only 14 weeks. Under the federal statute, it's now up to 39 weeks. And you don't have to show that you're searching for work, because obviously right now there's not any work that's out there. You could have this if you have a loss of childcare or school closings, and so you can't work. And on top of that, the amount that you're going to get is increased. So in Georgia, the amounts go from $44 to $330 a week. Now, even at the lowest end, you're still going to get an additional $600 a week. So everyone's going to get that $600. So, $644 or up to $930 per week. So if you're making anything, say $50,000, $75,000, the unemployment benefits might, under that, the unemployment benefits might end up being better than the sick leave benefits for people.
Can I interject a little side point here? From an employer's perspective, one of the most misunderstood concepts in what I do is an employer who thinks that when an employee goes and collects unemployment benefits, that it is a dollar for dollar transfer, that somehow the employer is paying for that person not to be at work. And that's indirectly true, right, at best. That there are insurance benefits that are paid out of an employer's payroll. You're paying them already anyway. It goes into an employment fund or an unemployment fund. And then as that account is debited because your former employees qualify for benefits, it's monitored. And if your account pays out more than you've paid in, the next year your contribution ticks up. And when I say it ticks up, it's a little bit. It is not dollar for dollar. It is not getting anybody rich necessarily. We'll talk about that later. But employers should not shy away from especially in these circumstances, from employees collecting unemployment. It's a safety net. It doesn't mean that an employer did anything wrong. It doesn't mean that the person should still have a job. It doesn't mean that they're liable for anything. That is a huge misconception. And once employers understand that it is an insurance benefit like workers' comp, like auto insurance, that's already been paid for, that makes it a little bit of an easier pill to swallow.
Right. It's based on a percentage of your payroll. And so if they find that you've abused it, which they're not going to in this situation, that's the idea of it right now. But if they did, what would happen is that percentage amount goes up just a little bit.
Yes. So that should make it an easier pill to swallow, right? So the increasingly rich benefit, and I use that term advisedly, the increasingly rich benefits that are being paid are not coming directly out of the employer's pocket. That'll be made up later and incremental.
I want to address or just touch on some of the questions that are coming in on chat. If you guys did not tune into Todd's last webinar or to Amanda and the radio show that Amanda and I did this week, there's information on the FFCRA on both our websites, and we've both done a breakdown of what that act means for employees and who's able to take advantage of those. So if your questions relate to that, that might be a good place to start if you did not already tune into the webinar, the radio show, or our blogs. In terms of the furloughs and the layoffs, I want to talk a little bit about companies who are, laying off tons of people in the face of this. Maybe entire companies are closing, or maybe they're furloughing a huge number of people, or they're laying off a huge number of people. What do both employers and employees need to consider if there's a need to do that? And with the new stimulus or the new relief bill coming, is there in some cases going to be the situation where there's maybe not a need to do that with the payroll loans and that sort of thing?
I'll take this first because Amanda is deeper into the bill. She's read it apparently about what's coming down the pike. But before we get to that, this is another element. Before we start slamming our doors, before we think we're hopelessly doomed on this, let's give it another few days to see what comes out of DC. And from what I understand about what's coming down the pike, it's going to be a lot of money that's flowing directly to employers in order to keep the doors open. We don't know what that is. I certainly am not promising it. I'm not guaranteeing it, but we'll see. If, though, you're at the point where the door, I'll let Amanda talk about that in just a second, but if you're to the point where you do have to shut your doors, there are several things that we need to look at. If it is a company that has more than 100 employees, they are subject to the WARN Act. And that's an acronym for the Worker Alert Relocation, or what is it? What's the acronym, Amanda? Do you know off the top of your head? Put you on the spot.
Nope.
It's the WARN Act. And the WARN Act is designed to allow governments and employees to know when their plant is getting ready to shut down. So in a typical non-apocalyptic environment, the company that's getting ready to shut its doors would have to provide 60 days notice to the employees, as well as 60 days notice to several labor authorities, the Georgia Department of Labor and any union, other things. There's a huge caveat in that if you don't foresee it coming, right? If it's a plant fire and you're not going to rebuild, if a coronavirus hits and you have to shut your doors and you're not able to provide those 60 days notice, there's unlikely to be a violation in this case, but there still are notification requirements. So we still have to notify the labor authorities, and if there's a union, that we are in fact shutting down. Of course, we've got to notify the the unemployment folks by giving the employees a DOL 800 in Georgia. Other states are different. And then there's still COBRA notification rights that have to go on. None of that applies if you're furloughing folks, and the furlough, the reduced hours, the layoff, whatever you're going to call it, is intended to anticipated to last less than 6 months. And then if it looks like it's going to last longer than that, you have to provide that notice. But those three things, if you're thinking about shuttering your business, are the things that you have to worry about. You got to worry about get your final paycheck out, whether or not you pay vacation, which is according to policy in Georgia. So those sorts of things. But I think that Amanda can perhaps alleviate some of those fears that maybe we don't have to jump to that doomsday scenario as quickly as we might have thought last week.
Yeah, and I want to point out on the unemployment, if you're taking these actions because of COVID-19, then you actually don't have to give the employee the separation notice, but you do have to file with the DOL on their behalf. And so that would actually trigger the unemployment benefits for individuals. And those individuals also include, looking at some of these questions now, they do include people who are TN visa employees. They also do include part-time employees, so that those options are available for a broader group of people than what we typically have. But what Todd's talking about is the Payroll Protection Act, and that's part of the stimulus, the $2 trillion bill that's coming in. And one of the benefits that are provided under that, the Paycheck Protection Act, the PPA, is that the Department of Labor, the Treasury has authorized the Small Business Association to give banks money to protect loans that the companies can take. So you're going to be entitled to 2 months of your payroll expenses, 2 or 2.5 months. I'm reading two different things. But if you go and you identify what your payroll costs are, which includes paychecks, wages, and includes for the executives or the self-employed people, and you add in your retirement benefits and health insurance benefits, that's going to be the total of your payroll costs. And you can look at either the time between January 1st and the end of February or the last 12 months and take that average. Banks are going to now be able to give you those 2 months of pay, and as long as you use it to pay for payroll, you maintain the same average number of employees, don't reduce employees' income by more than 25%, and you use that for paychecks, utilities, interest on your loans, or rent or leases, or mortgages, you will have that amount forgiven. So what that means is that the government is going to give you money for 2 months of that amount, and as long as you stay in business and pay people, you are going to not have to pay that money back. So that's obviously a huge amount. Companies are looking at taking that money and seeing, in this downturn, maybe there's a way for them to expand or to come back even stronger after what I anticipate is probably about 2 months of downturn in all of this, and maybe 2 months of work and all of that. But to be able to take that and the end of the 2 months come back even stronger than you are right now. So I know a lot of people are thinking, what am I going to do for 2 months? But I think there's lots of things that you can be thinking about for that 2 month period. But if you're getting that money, you can protect your employees, you can protect your company, and you can still be in business in 2 months.
Yeah, I think that's a very hopeful and positive approach to this, and there's still a lot of work to be seen how that comes out. That was the Senate bill you were reading, pulling that from, Amanda? That
was the Senate bill. Yeah. So it's 883 pages. I did not get through all of it, but I did read a good bit of it. And, it's a complex set of laws that are being put in place, but it's got a lot of benefits for people as well as for employers. And, I represent employees, but I'm also an employer of a decently large organization for a law firm. And so I'm looking at these types of things as well. And can I use this money to help those other people that are out there that are losing their job and create something that in a couple months that we come back stronger.
I think a lot of people are asking on the chat too about when this stimulus bill is going to be passed. I can give you, just a quick update right now. I think there's a little bit of friction in the House, but I would expect it to be passed this week. Would you guys not agree? I mean, I think if this one holdout on the bill continues, then it's going to cause all of them to have to congregate in person. I don't think that's going to make anybody happy, but I think it'll get done.
Yeah, I'm expecting it'll pass today. So, they meant that, and that some of these checks are going to start happening within 3 weeks. And the Treasury Department is going to be working with banks, so it's not any more limited just to the Small Business Association, which has had a tremendous amount of traffic to their websites, and so it's been very difficult. There is another option on the Small Business Association directly, which is the emergency EIDL, so disaster loans, economic injury disaster loans, I think is what it's called. And that's a loan that's also going to be available. It's not a forgivable loan, but that's a loan that people can apply for. It's a 4% capped on the amount of interest that's going to be paid on it. It can be a 30-year loan, which is great terms for a loan. And as soon as you apply, within 3 days, you will be given a $10,000 grant. So even if you end up not being ultimately eligible for that loan in the end of it, you still get that $10,000, and that's not something that you have to pay back. So that's a good place to start with, and that's an infusion of $10,000 into a business that can help you, in covering some of the costs that you have in this particular situation.
Yeah, and all of these things are going to the point, the overarching point of this webinar, which is slow down, right? We can get into and we're happy to get in as we move forward some of these questions, some of the nuts and bolts of how do I get through today? How do I get through tomorrow with my employees, and what do we talk about? But as we move into that part of this discussion, there is an economic life vest being thrown our way as employers, and that's a super perspective from Amanda's firm. She's an employer too. She's got to look at this from an employer's perspective, and we talked about it earlier. She, foremost among plaintiffs' counsel, does recognize the business side of this, right? She's not a fire breather like some other ones. That we work well together in order to make sure that good employers are not held to the same task all the time that deviant employers are, and her clients tend to be of a better caliber than others, we'll say. How about that?
Thank you.
So, go ahead, Amanda.
Oh, I was going to say, I saw a question about unemployment. The $600 benefit is for everybody who's on unemployment. So even if they're on partial unemployment, they're still going to get the $600 benefit. I also wanted to talk about just a couple other things that an employee can look for. So, I was just telling what an employer can do to get money to help to cover that payroll. For an employee who has retirement funds, that's also an option right now, is for people to draw down on their 401k or their other retirement benefits. And there's not a penalty for taking the money out like there would be typically. You can take up to $100,000 out instead of just $50,000, and that's all the way through the end of this year. So even if you don't need it now, or you need some now, you need some later, you can do that. You've got up to 3 years to repay it without penalty. And if you choose or can't repay it during that period of time, instead of it all being hit in 1 year, you can actually space it out over 3 years, so that tax liability for not paying it back will end up being something that's spread out over time. So it's another option for people who have retirement out there in case they're running out of money, to be able to get help there.
One other point on that, we get the question a lot about whether or not, I'll put this in quotes, quote, 1099 employees, close quote, are eligible for these benefits, be that unemployment, be that employee paid sick leave, and be that FAMLA, those sorts of things. allow me to digress for a second and point out that there is no such thing as a 1099 employee, that they are either employees or non-employees. They are either employees or they are contractors, vendors, subs, whatever you want to call it. But if they are 1099, they are not an employee. And technically, 1099s, non-employees, are not eligible for these benefits. Now, there's other relief that may be available to the self-employed that we can talk about later if that's important. But whether or not somebody is an employee or a contractor, as many of you have heard me say, is a matter of law. It's not a matter of agreement between the parties. And we see it happen a lot in which a company has been treating a worker as a contractor because it's easy to do, because they don't want to withhold taxes, they don't want to worry about overtime obligations, they don't want workers' comp. All of these reasons that flow directly to why they probably are employees. And so as these contractors who are likely misclassified as contractors rather than employees, as they go start applying for these benefits, the arrangement that you've had with these workers is likely to come unraveled. And once they are designated as an employee by one agency, it makes it more likely that they're going to be designated as an employee by other agencies, be that the IRS, be that the EEOC, for Fair Labor Standards Act purposes and overtime purposes. So if you have contractors on your payroll, we can't fix it right now, but make sure to take a look at that about whether or not they're truly should be able to be classified as contractors. There is other relief coming for contractors, but the blanket answer is that contractors are not eligible for the sorts of employee benefits that we're talking about, even if there's other alternatives that are out there.
Right, unless they've been misclassified, that might come into play. The unemployment benefits are now available for people who are self-employed or contractors. So if they're 1099, there is unemployment benefits where there didn't used to be. So that's good. It's not going to come from the employer. It's going to come from the employee going and filing and showing their information. But they're not going to have that sick leave options or the FMLA options
and that's from the bill that's passing this week, Amanda?
Yes. And yes, that's from that. I'm trying to think if Georgia has already put it into play, but yes.
And just to revisit, there's some questions that they want clarification about the loan that provides $10,000. That's Small Business Association.
Yep. What's the question? Is the question, what is that?
Right. You were referencing Small Business Association when you were talking about that.
Yeah. So that's called EIDL, which is the small business loans that's already in place. So it's not credit based, and you can go apply through the Small Business Association for a loan. They give you, within 3 days of your application being completed, a $10,000 grant up front. So even if you do not get the loan, you still have that $10,000 up front. So it's definitely something I would say to apply for, because that $10,000 obviously can help a lot for a lot of people. And then if you do get the loan, then that's a front to that $10,000 of what you get. It's taken out of what you ultimately get. If you get the loan, then you can have up to 30 years repayment at a 4% interest rate. So those are currently available. Under the stimulus bill, there's going to be a whole nother set of loans, and that's the Paycheck Protection Act, and that's the forgivable loan. So that's going to give you up to 2 months of pay, or 2 or 2.5 months of your payroll costs that you can then use for payroll, rent, utilities, and interest payments.
And that's huge.
And when I say rent,
I mean, a
I
forgivable
also mean
loan.
for mortgages.
Yeah, that's huge.
It's huge. Yeah, I mean, that's, and that's up to $10 million. So, most employers this is only for people under 500, companies under 500 per location, that are going to have that option. So not everyone's going to have it.
So what about if I'm an employer and I have 5 employees and I was looking to hire, so I have positions open, would I be able to use that payroll loan to bring on new talent during this time where people are looking for jobs if I've got work for them to do remotely?
Yeah, I think you could be bringing in talent. I mean, like I said, one of the things that I'm hoping we can do for our firm is find people who are out there looking for work. Even if there's not work to do, you can still be bringing them in and paying them. And that'll ensure that you're meeting the obligations that you have. And really the intent behind this is to stimulate the economy. So not only to help people who are struggling, but to get us at the end of this in a better place.
Right. So I can not only just maintain my business with this, I can grow my business. And I think that's another huge point to make.
Yeah. And what that means is that you can use the money that you might already have in the business for other kinds of things besides the payroll and your overhead, your rent overhead, and, use it maybe for marketing or whatever, purchasing new equipment, whatever your company might be.
So what about, we've got a question here, which I think is a good one, about salary reductions across the board, where employers are just trying to cut the fat and survive this. What can employees do, and what should employers do when they're looking at, just cutting salaries across the board? Is there anything particular we need to consider there?
So from an employment perspective, right, especially in Georgia and at will state, and unless there's a contract guaranteeing employees a certain wage, employers can modify wages, be that an hourly rate. We can modify that. We can modify a commission rate, and we can modify salaries. One of the things that we have seen a problem with is where people want to reduce an exempt employee's salary because they're not working as much. And that's okay, but remember, a salary is cannot be tied to the quality or quantity of somebody's work. So their salary should be for all hours worked, and that's opening up another dispute with me and Amanda, but that's neither here nor there. But if you're going to reduce an employee's salary, make sure that they understand, look, we don't have a ton of work for you right now. Your salary is still going to be for all hours worked, but we're reducing the load because we can't continue to pay for the same amount of wages when we're not getting the same amount of revenue in. So yes, you can lower those salaries. It can't be done frequently, right? You need to pick it and ride it for a little bit. And then the other thing is important: if you have a salaried employee, someone who is exempt, not exempt from the fair overtime standards of the Fair Labor Standards Act, if they work at all during that week, they have to be paid their full salary. So we can't take partial days off. We can't reduce their salary by the day off that they took. It has to be paid for an entire week for any work that's done.
So Amanda, if I'm one of those people who has their salary reduced, do I have any options for getting maybe some unemployment to pad the gap? I mean, would that be something that would probably qualify, or is it going to be, well, obviously dependent on my salary range, right? Is there anything I can do as an employee if suddenly I'm getting paid, maybe I'm working, but my salary is now cut significantly?
It's going to depend on if it's being cut because of the hours, right? So if it's a reduction in work, and a reduction in pay, you'll be able to get unemployment. But employers are still able to, even under the Payroll Protection Act, reduce up to 25% of the salary.
Sorry, Amanda, go ahead.
Yeah, so I was going to say, so that's probably it.
And that goes for hourly employees too. Somebody who's earning an hourly wage or a commission percentage. Amanda's right. I think that unemployment benefits are going to be tied to a reduction in hours. So if an employer comes in and says, I can't pay $20 an hour anymore, but I can pay $15 an hour, that employee gets to decide whether they're going to continue working for 15 or, I guess, quit or insist on 20 or try and split the difference at $17.50. But without a reduction in hours, I don't know that benefits would be available. On the other hand, if they say, I don't have enough work, I'll keep paying you 20 hours, but can only pay you for 25 out of the 40 that you normally work, I think that benefits would be available in that instance. As I talked about last Friday, remember too, though, that the Fair Labor Standards Act, as one of our attorneys put it, is not corona immune. And the Fair Labor Standards Act is still out there. We still have to pay people at least minimum wage for all hours worked. If you've got a server who is, you're normally paying $2.13 an hour, but they're not getting tips. You have to pay them $7.25 an hour. And for folks who are working hours in excess of 40, we still got to pay that time and a half premium if they're not exempt. So those laws are not on suspension during this crisis.
And I'll say the same thing, just to touch on it about FMLA. I think the expansion of FMLA, other than those 6 reasons, and then the one reason that it'll expand up to 12 weeks for employees who haven't been there a year, regular FMLA rules still apply. I mean, the care of a covered service member still has to fall under FMLA.
Mm-hmm. Or if somebody who's got diabetes is still eligible for, I heard it referred to as FMLA Classic, Family Classic the other day. So we can't forget about all the other things that we usually have to contend with, even as we're talking about these new exigent circumstances.
I think a good point too would be that employers are going to need to make sure that they're tracking hours. So as people are working from home, their time tracking systems may not be in place, and you may end up having people who are working more than 40 hours a week because they're working from home and don't have much else to do. And so that's going to, if they're not tracking time and the employee is working more and the employees are not getting paid overtime, that's going to be an area where the employer is going to be held responsible because they're no longer tracking time.
Yes, and I will go back to my axiom that employers should not use wage payment as a disciplinary measure. So if you have somebody who is not being productive during the hours they're recording or who works unauthorized overtime, pay them the money that they that pursuant to their comp plan, and use another disciplinary procedure to either increase the production or to quell the unauthorized overtime. But do not pay the overtime. Do not withhold money from them because you don't think they quote unquote earned it. That's inviting an FLSA problem. One of those questions that just came across about executives volunteering to work for free. Mm-hmm. No. If you ask those executives to cut their salary down to $684 a week and continue to pay them $684 a week so that they satisfy the exemption. If you have employees who are wanting to come chip in at a lower hourly rate, pay them $7.25 and time and a half for hours worked in excess of 40. But I would not go down the volunteer route in any regard.
Yeah, I was thinking that, Todd, when I saw that question. What about salary deferral? I know, especially for executives, when times get tight for companies, there's often executives will defer their salary. Any thoughts about that?
I don't think that poses, I think that the higher level you get in the company, the less of a problem the FLSA becomes, right? I mean, if we're talking about true executives and with some sort of deferral saying, I won't collect a paycheck during these times. I think that as long as the record keeping is there, as we know, everything's all right until it's not. And that salary deferral might look great on paper right now, but they might decide it was a bad idea later, might come back. I would just make sure that we keep really clear records on what's going on with that deferral. Amanda, do you have any experience with that? That doesn't come up very often, but I don't think it would be a problem.
No, it doesn't. I mean, there's not an executive I've ever heard of that has offered to go without pay, then turned around and sued for minimum wage,
right? Which
is really what the claim would be. So, that's an uncommon thing. I mean, yeah, not only uncommon, I've never seen that. So, and of course, if there's ownership and a certain amount of ownership in the company, then that executive is actually allowed to do that.
I'll touch on a couple of these questions that I'm seeing come through. Unfortunately, I think a lot of the sick leave and expanded FMLA may not be available to healthcare workers and people on the front line. Is that? Would you guys agree with that? There are exceptions for those folks, unfortunately.
Yeah, we looked at that for a doctor's office this week, but the important caveat here, it is the healthcare providers, right? It is the doctors and nurses. It's people who can diagnose and treat. It is not the exceptions don't apply only to them. So say for instance, a doctor's office that has the check-in clerk, the check-in staff, administration type stuff. Those folks would still be eligible for the leave. It is the
right.
The frontline folks, first responders, docs, and nurses not the support personnel.
And some of the questions I'm seeing come in, I did want to touch on this piece because a lot of the calls I know we're getting on our side of things have to do with anticipatory terminations. Employers, see these relief measures coming, and that, and I know we touched on this a little bit before when we talked about unemployment versus some of these other benefits, but where an employer chooses to terminate an employee in a way that doesn't let them take advantage of these FMLA expansions particularly. Can you guys just talk about that for a second?
Go ahead, Amanda.
So repeat the question for me. Whether if they're firing somebody because of trying to avoid it,
right,
then they're still going to be violating the law, right? So if the reason that they're taking action is an illegal reason so that somebody can't get the benefits, then that's still going to be a violation, just like it would have been before that under the FMLA, trying to prevent somebody from taking it because they're sick or would need time off. So, I think in making these decisions, the question is going to be, are you isolating and designating certain people for these decisions that are more likely to be able to use something, or are you making, decisions across the board about it? One of the questions I saw that came up was actually going back to the salary deferrals and asking about salary deferrals for employees. And I think that's probably going to get into, are they working, right? So if somebody's working, then you are going to have to pay them, but you can defer the portion of their salary. And, I'm interested in your take on this, Todd, but I think you can defer the portion of their salary that's above minimum wage and still be able to not violate any laws there. What do you think?
Look, I would look at this and say, if I've got an employee coming in and saying, look, I know times are tight and I know work still has to be done and I know you might not be able to afford it, they're likely, if they were willing to work for $0, they're willing to work for $7.25. Much like interns, we get this question a lot for that, right? In other happier times. But go ahead and you're right, check that FLSA box, pay them minimum wage, and time and a half for hours worked in excess of 40. But employees can always agree to work for less than what they're working for. Employers can always agree to pay more, subject only to those Fair Labor Standards Act or local wage payment rules, right?
And I would think
and I think at that point
sorry, go ahead.
I was going to say, and at that point, what you're talking about is a contract to pay back that person at a separate point in time.
That was the point I was going to make. The employer on a deferral is really acknowledging they owe the money. It's not that they're saying they don't or they're not going to pay it. So,
yeah, and they can condition it, of course, on the company being open and things of that nature too.
Yeah, the one thing I promised myself I wasn't going to get distracted by this chat. It's really hard not to as it's going.
There's some good questions there.
That please, employers, do not tie salary to a specific number of hours worked unless that's already been agreed to, right? I recommend that employers have in all of their employment agreements that your salary, your wages are intended to cover all hours worked. That allows us to take advantage of being much more flexible with the overtime rates. And so one of the ways I can see this cropping up is if during this time, you go in and you say, all right, well, we are going to reduce your salary because you're only working 20 hours. Well, that gives us such that your salary is now tied to 20 hours. When we go back, it's going to be an easy argument for the FLSA claim to say that's tied to 40 hours, right? So we got to stay away from that. And that's a perennial point of argument dispute between plaintiffs and employment firms is how we calculate that regular rate. So don't step in it and make it later on that point. I also need
sorry, go ahead, Todd. I
need to correct one other thing about if we have healthcare practitioners on here. Nurses, for whatever reason, are not considered healthcare providers. That's surprising to me. I just got a text from the attorney who researched it for us. Nurse practitioners and nurse midwives are. Nurses themselves are not. So in any event, if you have questions about that, let's dig in a little bit onto that. But for right now, it would appear nurses are eligible for those paid sick leave and FAMLA, but that seems counterintuitive to me.
And there have been several questions about when that comes into play. I think the consensus is that it's April 1st. Do you see anywhere where that might be reaching back prior to April 1st, other than the anticipatory cases I talked about, where you know they're going to need that FMLA and you're firing them because you want to avoid them taking advantage of that benefit?
No, I don't. In fact, I think the law is pretty clear that this is intended to go into effect on April 1st or 2nd. All right, I think it's April 1st. What is the earlier date of the two? Anyway, but I think it's pretty clear that those benefits are going to sit on top of whatever has been offered or provided before. And so if you've advanced folks paid sick leave from an employer perspective, they are going to get more sick leave if they qualify under the EPSL. I don't think you get credit for time served when it comes to look back on that.
Brian Akers has a question about the EIDL and whether the forgivable initial 10K will be lumped into the actual loan.
You'll get that 10K within 3 days of completing your application. If you get the loan, then that 10K will be credited against what you get. So if you got 50,000, you'll get another 40,000, for example. But if you end up not qualifying for the end of the loan, that 10,000 is going to be just a grant to you, so you don't have to pay that back. I believe that it's a grant either way, and that you're only paying back a portion, but I'm not 100% sure about that.
So in our last few minutes here, Todd or Amanda, do either of you want to raise any points that haven't been raised in the chat questions or that we haven't covered in our discussion so far that we may need to touch on?
The question that we get a lot are employer care questions, meaning I've got somebody who is 65 years old working in my office. I'm scared that they're going to get coronavirus. Can I send them home? The answer is yes, if you want an age discrimination problem, right? That even benign, even benevolent reasons for those distinctions still hold employment law peril. If the 65-year-old employee or someone who else is somewhat susceptible says, I'm nervous about being here and I would like to go home, work with that employee in order to provide them the ability to feel safe. You can reassure them about your hygiene process. You can work out a PTO, allow them to take vacation. You might be able to arrange some sort of modification. Who knows what can happen, but please don't take it upon yourself to determine who you think is susceptible to these things and try to help. One of my axioms is that no good employer deed goes unpunished. And I think that you're walking a perilous line if you try and help like that.
This is something you and I discussed the other day on our show, Amanda, though. If the employee is showing symptoms of COVID, a cough, a fever, what would you say about that?
At that point, that's implicating the direct threat. And so sending them home because of that is going to be something that's is allowable. That's not a problem there. I would say, too, that it's not going to be a violation of the Age Discrimination Act if you're sending them home and you're continuing to pay them. Because under the Age Discrimination Act, the only time they're going to have a claim is if they have a loss of wages.
Good point. One other thing that keeps coming up over and over again is people are asking for how they document things for employee paid sick leave and emergency FAMLA. We don't know yet. We have a compliance package that's standing by with updated policies and what we think the forms are going to look like, and what you can ask for, what you're not allowed to ask for, how you're going to quote unquote prove that how the employee is going to prove that they qualify for this leave. We don't have the details on that yet. And we're hoping for more direction from the DOL and other agencies coming up soon. But as of now, we don't know how that's going to work. And I keep falling back to my default position, which error on the side of assuming that if they are claiming that they qualify, go ahead and let them qualify. It's not that much money in the long run, and it's certainly going to be cheaper than untangling it later.
And there is a DOL fact sheet that is considered now a poster that's supposed to be posted in the workplace about the sick leave. And so I would recommend getting that and emailing that out to your employees, because obviously there's not really a posting option for most employers right now.
Yes, and that's part of a good communication strategy to let your employees know what's coming down the pike. Because if they have misconceptions about what the law affords them, in my experience, expectations are premeditated resentments, and if they don't understand what it is that they're getting, they're going to be angry if they don't get it. So more communication from employers is better, not less.
Mm-hmm.
The DOL fact sheet is available on the DOL website. It went out in Stanton Law's update today. I would imagine that Barrett Farahany will have that available as well.
Speaking of what we have available, I want to let people who are employees know that if they have any questions, Kathy leads our case evaluation attorney team, and we have 7 attorneys that are available to answer any of the employee side questions that people have. And you can go to our website at justiceatwork.com and sign up on our site for a time to speak with one of our attorneys, and one of our attorneys will talk you through any questions that you have about your employee rights.
One of the things we've put into place also is a coronavirus COVID resource page, and we're adding to that daily. You know, where can you get, if you're an employee, where can you get assistance and funding? If you're looking for a job, where are the places that are hiring for remote work? All manner of information and resources on those pages we're building, and we're adding to that daily. So,
and employers, we ask you guys to send to some of those pages as well. It includes things like, you know, what the utility companies are doing and what the mortgage companies are doing. So it's more to give people the understanding of what their resources are in this time as well.
And of course, for employer side questions, we're happy at Stanton Law to field those. We also have a resource page at www.stantonlawllc.com, and we're accepting email inquiries over info@stantonlawllc.com. And we have a similar, not quite as automated as Barrett Farahany's way to set up a quick appointment with an attorney to get your questions addressed. We're committed to doing that round the clock until this thing gets done. So set up an appointment and see if we can help.
any last minute thoughts? Any last minute questions? We've got about 2 minutes left.
I really want to say again that this the idea between Barrett Farahany and Stanton Law I think was a good one, and I hope that it demonstrates that although they're usually we could be pretty antagonistic with one another, in this instance it really has been interesting to see their side of it, and I see as much as anything here now the good employers and good employees really have an obligation to carry this forward, and we'll let the bad employers and the bad employees sort it out later. But let's focus on the people who are trying to do it right for now, and we'll let that.
Yeah, I told Todd starting off, it's probably not going to be the people who are on a call like this that are the ones that are going to have the problems, because they're looking at and trying to figure out how to avoid those problems coming forward. So going forward.
Well, we thank everybody for joining us, and we hope what we've shared with you will be helpful. And I think you know where to find both firms if you need us. And I'm sure Todd will have other webinars coming up, and Barrett and Farahany has a radio show you can read about on our website that we're going to be doing regularly. So thanks again for joining us.
Thanks, everybody.
Right. And on that for this last one, we did talk about COVID and employee rights. So there's some other things that we talked about on there as well.
Thanks, guys.
Downloadable.
Thanks, everyone.
Thanks, everyone.